Welcome to the Functioning Law Podcast, where we make the FLK your friend and not your foe. I'm Theo, your guide to SQE1's success, breaking down the changes in English law so they make sense, not headaches.
And I'm Anna, SQE Candidate-in-Chief and permanent resident of Revision Land. Today we're talking about something that's reshaped the civil justice landscape, the big changes to civil litigation for 2025.
That's right. In the last couple of years, the English civil procedure system has undergone what many are calling the most radical reforms since the civil procedure rules were introduced in 1999. It's a triple whammy. ADR has become integral, fixed recoverable costs now dominate most claims, and the litigation funding model has been shaken to its core.
So, in short, anyone preparing for SQE1 or thinking of litigation in practice needs to throw out the old assumptions and get to grips with this brave new world.
Precisely. And let's start with ADR, or Alternative Dispute Resolution. Until recently, ADR was always encouraged, positively framed, but ultimately voluntary.
The polite suggestion from the court that you might want to try mediation before going to trial, yes?
Exactly. But all that changed with the Court of Appeal's decision in Churchill versus Merthyr Tydfil County Borough Council. The court now has the power to compel parties to engage in non-court-based dispute resolution. This marks a significant departure from what was previously thought to be established law under Halsey versus Milton Keynes.
So, what did Churchill say, in essence?
The key holding was that the Halsey judgment, often cited as barring forced mediation, was misinterpreted. In Churchill, the Court of Appeal clarified that courts can order parties to take part in ADR, provided it's proportionate and doesn't undermine the right to a fair trial under Article 6 of the European Convention on Human Rights.
So now, the court can actively manage a case by not just encouraging ADR, but requiring it.
Correct. The civil procedure rules have been amended accordingly. CPR 1.1, the overriding objective, now includes using and promoting ADR. CPR 1.4 and CPR 3.1 give judges the power to direct parties to participate, and CPR 44.2 allows the court to take a party's refusal to engage in ADR into account when deciding costs.
That's huge. It turns mediation from a nice-to-have into a must-do if the court tells you to. What does this mean for SQE candidates?
It means understanding ADR isn't an optional topic anymore. It's now embedded within litigation itself. And knowing how ADR affects timing, costs, and outcomes is central to advising clients effectively.
Okay, so let's talk costs, because I keep hearing fixed recoverable costs like it's the new buzzword.
It's more than a buzzword, it's the new normal. From October 2023, FRC applied to most civil claims valued up to £100,000. This includes claims in the fast track and the newly introduced intermediate track.
New track alert? What is this intermediate track?
The intermediate track sits between the fast track and multi-track. It's for relatively straightforward claims between £25,000 and £100,000, where trials are expected to last no more than 3 days, and oral expert evidence is limited to 2 experts per party.
So we now have 4 tracks.
Yes. Small claims up to £10,000, fast track £10,000 to £25,000, intermediate track £25,000 to £100,000, and multi-track over £100,000 or complex cases. Both fast track and intermediate track cases are now assigned to one of 4 complexity bands, which determine the fixed amount of costs that can be recovered.
So the band a case is placed in affects how much a winning party can claim in legal costs.
Exactly. And that's why track and band allocation is becoming a major point of litigation strategy. Claimants will argue for higher bans, defendants will argue for lower ones. It's not just about how complex a case feels, but how you can argue that in the directions questionnaire.
I can already hear the exam scenario. Advise the claimant how to argue for Band 3 rather than Band 2. It's not just legal knowledge, it's positioning.
Precisely, and the tables for fixed costs are detailed in Practice Direction 45. For each stage of a case, from issue to disclosure to trial, a specific sum is recoverable depending on track and band.
But just to clarify, this is the amount the other side pays, right? So what if your own solicitor charges more?
Then the client pays the difference. This is known as the costs shortfall. FRC limit what the losing party must pay, but not what the solicitor can charge their own client. It's vital to explain this to clients right at the outset.
So the solicitor's duty now includes not just legal advice, but financial transparency about costs risk.
Exactly. The SRA's updated guidance makes this crystal clear. Clients must be told what costs they'll likely incur, what's recoverable, and what might not be. This is now a professional obligation, not just best practice.
Let's pivot to litigation funding, and let me guess, this changed too.
Indeed. The 2023 Supreme Court decision in PACCAR reclassified many litigation funding agreements as damages-based agreements, or DBAs. That means, unless these contracts complied with DBA regulations, which most didn't, they were unenforceable.
That must have sent shockwaves through the funding world.
It did. Many ongoing claims risked losing their funding. Claimants, solicitors, and funders scrambled to renegotiate terms. It led to real uncertainty. The Civil Justice Council responded with a report in 2025 proposing formal regulation, greater transparency, and a legislative reversal of PACCAR.
So if I'm advising a client thinking about funding their claim through a third-party funder, what should I say?
You should advise that the regulatory landscape is evolving. Disclosure of funding arrangements is now required early in proceedings, and the risks of unenforceability are real. Clients should obtain independent legal advice on any funding agreement, especially if it involves a percentage of damages.
And just when I thought we'd reached the end of the roller coaster, you remind me of SLAPs, strategic lawsuits against public participation. What's going on there?
Another important reform. SLAPs are claims intended to intimidate or silence critics, especially journalists, through abusive litigation. The CPR now includes rules allowing for early dismissal of such claims and costs protection for defendants.
So, if a journalist is sued by a billionaire in a defamation claim, the court can strike it out early if it's clearly a SLAP.
Yes, under CPR 3.42d. If the claimant can't show the claim is more likely to succeed at trial and the court considers it a SLAP, it can be struck out. And under CPR 44.2, the court may refuse to award any costs to the claimant, even if they win, unless the defendant misbehaved.
I can see how this protects public interest journalism, but for us as students, it's another layer of procedural law to understand, especially how the court balances freedom of expression against access to justice.
And it reinforces the broader point of this episode. Modern civil litigation is no longer just about turning up in court. It's about strategy, proportionality, and regulation before, during, and after trial.
So let's summarize. First, ADR can now be mandatory. Second, fixed costs dominate for claims under £100,000 via a new four-track system with complexity bands. Third, litigation funding is under reform post-PACCAR. And fourth, we've got anti-SLAP rules protecting the integrity of litigation.
Exactly. And these are not just updates for practitioners, they're exam relevant. The SQE1 FLK on dispute resolution has to reflect this new reality. So stay sharp, stay current.
And if you want to stay current, remember to subscribe to the Dr. Yannis MCQ SQE newsletter for your weekly fix of practice questions.
Subscribe to the Dr. Yannis YouTube channel for more on these reforms.
And of course, press like and share the podcast with your study group. Let's make the SQE FLK community stronger together.
Until next time, good luck with your prep. And remember, the best litigation strategy starts long before you enter a courtroom.